So this next question is, how do you determine if your idea qualifies for trademark or patent or other protection? And the way I think about it is, there are certain legal tools, right, that allow you to take an idea. Nobody can own an idea. But once you wrap it in some sort of intellectual property, it then can be owned. It becomes property, right? An idea um, becomes property using intellectual capital or intellectual property, right? So there are different tools to go about doing that. It depends on what you're trying to protect. So I will typically sit down with a client and try and find out something about their business to figure out what tools are available to take some of those things and convert them into intellectual property. And unfortunately, not everything qualifies. There are exceptions to what you can patent. There are things that qualify for trademark protection or copyright protection, or trade secret protection. And those are generally the legal tools that are available. There's a lot of others. I could talk for an hour on that topic. But every company has a name, right? And certainly you can trademark that name. A trademark um, goes after words or symbols or sounds, anything that's a source indicator of the products or services that you're selling. So certainly every company has a trademark that can be filed. Now, you'll often get some rights to an idea, perhaps just by um, using it when it comes to a trademark. So um, there are what's called common law rights, meaning that you don't have to do anything legally to protect them. So by using something as a source indicator, your business name, you start to accumulate common law rights. And those can be enhanced by federal trademark registration. There are state trademark registrations that you can do too, but they're less popular than the federal ones. But you get common law rights in the trademark. It generally is commensurate with the scope of what you're selling. So if you have a corner grocery store and you're using a name, it would probably be for that little area of people that might buy groceries from there. It might extend a little bit further if you're near a freeway and you get a lot of people come from different areas, but it'd be those people that would normally be exposed to your trademark would be the ones that would define the scope of the common law rights. If you're selling online, it might be more, right? Because you might be selling in most states, but maybe not every part of every state. So as you start to operate or have customers in multiple states, you qualify for filing a federal trademark registration, which gives you constructive use in all states. So people will generally do that if they're um, going over a wide geographic area. They go country by country. So you would have to file in the countries that you're using it, and the rules are different in different countries, and there are shortcuts to doing it. So any sort of indicator source, so it can be your company name or a product name or something like that, can be trademarked. Cost usually prohibits you from trademarking everything. Um, Copyrights, any artistic expression in a tangible form. So it's not the song sung, but if you recorded the song, that recording could be protected by a copyright, or if the sheet music were written out, that could be protected by a copyright. And with copyrights, you have common law rights also by creation of that tangible form of the thing. You get common law rights. And people often will file a federal registration because you get enhanced rights. You can get statutory damages, and you can file in federal court. But you can't file on everything generally. And certain things are never going to get out in the public, so you might not want to waste the money. And by filing, you would expose them to the public. One thing that people often forget about is software code. Software code is artistic, not the functionality. The functionality can be done in a number of ways, but if you take that code and just copy it over without authorization, you violated somebody's copyright, even if they haven't filed. And then trade secrets. A trade secret is anything that gives you advantage over your competitors that isn't known. So it might be a formula, or how you go about making something. And generally, it's appropriate for things that are not exposed to the public. A lot of things can be reverse engineered, but there might be a process within your enterprise of how you go about doing something that's much more efficient, and that gets trade secret protection, which doesn't require any sort of government filing to protect. Under the common law, you get those rights so long as you keep it secret and put protections in place to make sure that people don't take it. So you'll sometimes have to share information with vendors and stuff like that. You might have a contract there, a non-disclosure agreement. But if somebody broke into your building and stole the formula and started selling it online, you could go pursue litigation against them for trade secret violation. And then patents is the last big one, and it tends to be the most expensive because patents don't protect themselves. There is no common law protection for your idea. So the second you disclose it, or somebody can figure out, or they can independently come up with it, you can't stop them. So you can file patents federally, file them in the US, you can file them overseas. There's ways to kind of coordinate that, and there's some synergy associated with it. But you don't have protection until your patent issues. And then you can go and sue somebody if they violate your patent. And the patent, you look at these things, they're fairly confusing. The end has a set of claims, and the claims define the scope of what you own, not the rest of the document, not the summary, not the abstract, not the title. It's really those claims. And sometimes those things don't correspond very closely. So at any rate, it's a long answer. I could talk for hours on that particular topic, but if you talk to an intellectual property attorney, they should be able to, learn a little bit about your business, think about what you're trying to protect or own, and then they can suggest ways that you might use these legal tools or put in procedures in place to capture as many of these ideas as intellectual property. So you're either following the rules when it comes to the common law stuff, or you're doing some of these government filings when it comes to copyrights, trademarks, and it's required to do a government filing when it comes to patents. So anyway, it's a long answer, but it could be far longer. But I hope that helps at least give you a few of the things to think about. As ideas generally can't be owned, but you either have to follow the rules or do a government filing to convert them into property, and then they can be bought and sold and protected and that sort of thing. So anyway, if you got something from the video, hit the thumbs up. If you want to subscribe, you'll get these videos in your feed in the future. And let us know if you have any questions in the comments below, and we'll try and get to those questions in a future video.